Good afternoon. Welcome to the Appellate Division First Department. We have over 6 hours of oral time requested this afternoon, so please bear that in mind when you ask for the time. Understand that we have your record, we have your briefs, and we're fully familiar with the facts of the case. So I will call the calendar now. People versus Ridge Herbin. Submitted. Minahan versus New York City Transit Authority. I'll give you 4, 1, and 4. Pandora D, submitted. People versus Jamar Chomley. Submitted. Kerr versus Garcia. I'll give you 5. 5 and 1, 5 and 1, and 5. Atlantic Mutual versus Greater New York Mutual. Thank you. An-LYH Investments versus JDS Principal.
Respondent 6.
5 and 1 and 5. Thank you. People versus Cecil McKenzie is submitted. Ovid and Ovid versus Google.
Requesting permission for my colleague to argue the case from NYC.
Granted.
And then also 7 minutes should be fine.
Okay. 5 and 2 and 5. Thank you. United Hay versus Heronian.
Your Honor, 7 and 2 would be fine.
4 and 1 and 4. Intrepid Investments versus Selling Source.
Your Honor, for selling source, 4 and 1.
For Appellate White, 4 and 1 as well, please. 5 for respondent.
4 and 1, 4 and 1 and 5. People, thank you. People versus Carlos Santana. 4, 1 and 4. Thank you. People versus Keown Stone. Submitted. Coyle versus Dos Santos.
Plaintiff appellant requests 5 and 2, Your Honor.
5, 2, and 5. U.S. Bank Trust versus Stewart. 5, 2, and 4. People versus Sammy Artist. Submitted. Payne versus Rosenberg is submitted. M13 and M15 Holdings versus Athenson is submitted. And Sanitation Salvage versus the City of New York is submitted. The first case for argument is Minahan versus New York City Transit.
Good afternoon, Your Honors. May it please the Court. Jason Steinberg from Harris, Keenan Goldfarb, representing Ms. Minahan here. When a defendant gives us an unequivocal or equivocal answer, basically saying upon information and belief, we don't own the subject area in question. That, to us, is not a sense of finality. And in response to that, we will
Was
serve
the
a notice to
NTA
admit.
properly served? The notice to admit, was it properly served? In the
Yes,
first
it was. It was served by email. There's an affidavit of service confirming that it was served upon the attorney of record in the case. It was served upon the city.
It was served during COVID, right? Wasn't it the period of COVID?
It was right when COVID just started.
Okay, and then
when
there were
everybody shut down.
And then there were a couple of discovery appearances or opportunities to raise issues. Was that ever raised on discovery?
Well, it would
before
be,
the
if
court?
anything, they didn't respond. It would be on them to say.
My
we need-
question is, was it raised by you?
There was no reason to raise it because it was deemed admitted by us.
So the
fact
answer
that they
is
didn't
no.
respond. What?
The answer is no,
The
then?
answer is no. all right? And that is because once we serve it and they don't respond within the period of time, of course, we are entitled by law to rely upon those admissions. We don't need to seek a follow-up on a response to a notice to admit. There's no case law that says that.
Especially when you're asking about what seems to me to be an ultimate issue in the case. Don't you want to make sure that you can nail that down?
Well,
At your conference, why don't you just say, hey, Your Honor, by the way, this has been proved already.
Well, it's not an ultimate issue in the case. Hernandez says that, has specifically rejected that argument when we're dealing with just minor issues of ownership. It's a simple question. Do you own the grate? Yes or no? Not upon information and belief, we don't know, and then you don't respond to the notice to admit. We're led to believe that it's the subway system, it's the TA's grate.
Well, it was a straightforward issue, but it was a significant issue in the case. I think as Justice Moulton indicated, that there's that body of law that says if the issue is material or contested or goes to the heart of the matter, then the notice of admit is not a proper device to seek the admission.
In Hernandez, the court addressed that very specific issue. And when the court evaluated the notice to admit in that case, the court specifically held the notice to admit, which addressed matters regarding the ownership, control, and duty to maintain the metal grating upon which plaintiff allegedly fell, did not demand answers to material issues of fact. Because, like I said, it's as simple as ownership. And when we have a subway line that's running underneath those grates and transit does not respond to a notice to admit, it's pretty much, oh, it's their grate. Let's move on with discovery. They litigate the case for 3 years, and then in their motion for summary judgment, oh, by the way, the associate project manager we sent out there looked at a 1938 plan and says, whoops, we don't own a grate. It might be the budding property owner.
That's not all he relied on, of course.
What?
That's not all he relied on, of course. He relied on his own experience, what grades look like. He does that for a living, so he had other.
He didn't say that, though. He didn't say, I buy
But here,
You brought
ultimately,
an action against other parties, right?
I'm sorry?
You brought another action against other parties for this defective grading.
We did that in response to this questionable allegation to protect our client because the statute was running at that point. Remember, this was 3 years after the accident where he testified and says
But
this.
you were able to act before the statute expired.
I will say that the owner in that case, we did sue against the private owner, denied ownership of the grate and the sidewalk. So we do have a problem with that. That is prejudicial to us because, assuming this is correct, but as far as we're
sued
concerned,
Con
Transit
Edison
owns
as
the
well?
grate. There's no reason for the second action.
you sued Con Edison as well as the abutting owner, property owner,
We sued the budding property owner who has denied ownership of the grate.
and also Con Edison.
Correct. So the prejudice to us is, now, by the way, the judge relied upon a second department case saying, oh, it's the city's grate. So Transit says, on one hand, it's the private owner. That's what Hernandez said in his affidavit. Oh, upon information, I believe it's the abutting property owner. And then in the motion, they argue, well, it's the city.
You haven't
Pursuant to some
really
lease they never
refuted-
attached.
You haven't really refuted that it's not the TAs.
Sorry?
You haven't really refuted that it is not the TAs.
They have not refuted it. They haven't refuted it. So
They say it's not ours.
based on inconclusive evidence and speculation, based upon an associate project manager who also said that the sidewalk was repaired.
What's your evidence that it is theirs?
The evidence that it's the TA's grate is the subway line that runs underneath it, the grate, which is to provide ventilation for subways, their admission by not answering the notice to admit, and the Hernandez case, which specifically states by common law, your admission is deemed an admission of ownership.
If we get away
we are
from-
entitled to litigate the
Counsel,
case.
if we get away from the notice to admit and just look at the proof, they did have someone who was the property manager who went back and saw what was there. He said, the plans are there from 1938. That's where amendments would be kept. There are no such amendments, and that indicates that we don't own it, and no grates that we have are consistent with that size. Isn't that?
Hernandez's testimony is incredible because he also said in the same affidavit, swearing under oath, I went there and that sidewalk was repaired. We refuted
Well, he
that.
was looking at a different portion in the sidewalk. But didn't he say that the sidewalk grate that he was looking at was further to one direction or another, I believe?
Yeah, in the affidavit, he said the sidewalk had been repaired. So,
And even if that's the case, it still has to do with the size of the grate. He's accurate about the size of the grate.
he submitted no proof of that. There was no foundation for that, based on no documentation, nothing to substantiate. It was a conclusory assertion. I'm the associate project manager, and the grates for subways are smaller than this one, but there's no foundation for that testimony.
Thank you.
So do you argue that his failure to to challenge the notice of amendment was an issue of fact in the summary judgment analysis?
The
That
notice,
should have required the court to deny the motion? Is that your argument?
our argument is that summary judgment should have been granted to the plaintiff, not even, that this
So you feel you met your burden on your motion?
absolutely. And the notice to admit is controlling in this case because Hernandez specifically says so.
Thank you.
Good afternoon, Your Honors. May it please the Court, Teresa Frame from the MTA Law Department on behalf of defendants. This notice of claim was improper in many regards. The first way it was improper was that it addressed a material fact in this matter that had already been denied in Transit's answer. The second reason that it is improperly served. It was served via email only. It was not served by any technique that is recognized under the CPLR. CPLR 2103B does not provide for service by email.
Sorry, just back to the propriety for a second.
Yes, Your Honor.
Your friend gives great weight to Hernandez. Can you distinguish Hernandez?
Certainly. Hernandez is distinguishable on several grounds. First of all, the service issue. Second, the defendant in this matter, unlike the defendant in Hernandez, provided proof of its absence of ownership, the fact that it did not own the grade. So the material issue, the material fact that was disputed here, there is proof regarding it. In Hernandez, there was no such proof. The second way that Hernandez is distinguishable is the statute of limitations in Hernandez had run at the time of the notice of admit, or at least when the notice of admit became an essential part of the litigation. Here, the statute of limitations had not run, and in fact, plaintiff admits that other entities have been sued for the responsibility of this grade. Moving on, in any event, the notice of claim is not controlling here because a court is permitted to allow a defendant or any party to withdraw an admission, and that's under such terms that may be just and at any time, and that's CPLR 3123B. There are no further questions on the notice of admit. I'll move on. Defendant's witness, Herberto Hernandez, established through his testimony and his affidavit that this grate was in fact not a subway grate. Hernandez used two bases to make that assertion. First, the TA plan with the sidewalk gratings, which showed that there were no subway gratings at the location of the plaintiff's fall, and the second is his personal inspection of the grate where the accident occurred. Hernandez saw that the grate was much narrower, much wider than any subway grates that he had ever seen, and he used his own experience to make that determination. As a last issue, if this does in fact go back to Supreme Court and the issue of ownership is still disputed, the Second Department's decision in Fajardo and this court's decision in Garrett will control. The defendants do not own any of the subway grates in the city of New York. They are owned by the city of New York. Under a lease, we are leasing those, and under those two decisions, we do not have the responsibility for maintaining the sidewalk within 12 inches of the subway gratings. There are no further questions. I'll rely on my brief. Thank you.
Thank you.
The fact that counsel just said, we don't own any of the grades in the city of New York, it's the city's grade, calls into question, right there, Hernandez's affidavit, where he's saying it's the private landowner's grade. You can't have it both ways. They're talking out of two sides here. And that's prejudicial to us, and it's just like not responding to a notice to admit where we've alleged and sued based upon our investigation of a subway being underneath that grade. We've relied on their notice to admit, and the statute has since expired. When they filed their motion for summary judgment, the statute had expired. That was the first time they argued from a legal standpoint with this lease, the city. They haven't even attached the lease. They didn't even put the lease in the papers. At least in the other cases, the Second Department case and the other Garrett case, the court had the lease in front of them to review it. And even the First Department, this court held there's an issue of fact based upon, in the Garrett case, the court held there's an issue of fact based upon the lease as to whether transit caused the defect. So that, at least the court could look at the lease. You can't even do that in this case.
Thank you.
It would be prejudicial to us.
Thank you both. Kerr versus Garcia.
May it please the court, my name is Carolyn Canzanieri for the plaintiff appellant Larry Kerr. It is our position that the lower court erred in granting summary judgment to the defendant building owners, as there are issues of fact of whether this incident concerning Larry Kerr was an assault versus a matter of self-defense here. Those factual issues should be for a jury to decide. Whether this was a foreseeable situation, especially the fact that Michael Garcia testified, he's a superintendent on call 24 hours a day, 7 days a week. He was responsible for maintenance of the building. He was responsible to clean the exterior, including urine that was on the building. And during the incident, he was afraid that the glass would break, and that is the reason why he intervened. There was also never any instructions given to Michael Garcia to not put himself in harm's way and to contact the police if anything should happen with the building, and that was the reason why he had stepped in. With regards to the defendant building, they submit an affidavit of Richard Hill, which is fiend, to try to state that he was given, Michael Garcia was given instructions never
You think that was a feigned? You think that was a feigned issue? That it's just contradicts the other testimony or the other statements?
Well, the testimony of all the parties and Michael Garcia submits an affidavit himself saying he was never given any kind of rule concerning he should never step in concerning putting himself in harm's way. Therefore, in this matter, this act was within the scope of employment. This was in the furtherance and interest of the employer. And with regards to the case of Ravello versus Waldron, the employer does not have to foresee the precise act or the exact manner of the injury for them to be responsible in this case.
But it's not an occupation where normally the employee is authorized to use force.
Well, in this situation, Michael Garcia testifies that it is his duty to protect the building, make sure that it's clean and safe, and that's the reason why he had stepped in. He also testifies to the fact that he was worried about the glass being broken to the front of the building, and that's the reason why he had stepped in for the safety of the building. Therefore, it's our position that all of his actions were in furtherance of the employer, which is the building owners in this case. Secondly, the other argument that we had made in our papers is concerning the negligent hiring, retention, and training of Michael Garcia. They should have known his propensity to act in this manner, as he had a prior history of assault in a very similar instance as this assault occurred here.
Was that the disorderly conduct from approximately 20 years prior to the incident here?
From Sports Authority, and the defendants never properly screened him, like the case of Kenneth R. versus the Diocese of Brooklyn.
He was hired by, he was in the employment of the employer of the previous owner, and he just continued with the building, is that right? And it was, how many years did you say?
It was 20 years ago, but it
20
was
years, and there were no incidents in between that.
Correct, but the thing is the case law does show that the defendant should have done a proper investigation and background of the defendant.
When you take over a building, if you inherit any staff, there's an obligation, there's a duty to do a personnel check on everyone that you inherit.
Yeah, the owners were supposed to do a background check here when they inherited him with the building.
Well, this would have been a question of the employee or to the employee if they're going to take over staff to see what kind of prior history the person has. I mean, the incident is directly and exactly what he did in his prior employment with Sports Authority of insulting a person.
Even though that's 20 years earlier when there's not been any incident. That's what you're saying.
Yes. Just like in Kenneth R. versus Diocese of Brooklyn, the court did state that the defendant should properly screen and hire applicants. In this case,
And anyone who takes over a business and inherits staff has to do a background check on everyone that's employed there.
well, similar to the case, or had they have done some kind of background check, they would have known that there was an
No matter how
assault
many
similar.
years they're there, and
it's still their duty as a building owner that they should want to know what kind of employee they have on staff.
Normally, it's, the burden is a little higher on the hiring authority to do due diligence, and then that's the negligent hiring. And then the negligent retention is, okay, does something happen once the employee commences employment that gives us notice that the employee has a propensity? And then does the employer take action or not? It seems like a pretty steep burden, as Justice Friedman and Justice Rosado were mentioning, to now put this almost on a re-screening process.
Well, and there's also the claim of negligent training. I mean, because they didn't train Mr. Garcia whatsoever, and that's stated in his affidavit in contradiction to Richard Hill. The last point I just want to make quickly is the adverse inference charge concerning Larry Kerr deleting Frank Rivera's phone number, which he had stated during his testimony that, well, 4 weeks after he had multiple brain surgeries, he did delete Frankie Rivera's phone number. He did testify to that under oath at his deposition, and there was never any further notice for discovery inspection by the defendants, and they could have done their own search if they wanted to do a non-party deposition of Frankie Rivera, who lived in Pennsylvania.
Thank you.
If Your Honors have no further questions, I'll...
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court, Laura McKenzie from Morrison Mahoney on behalf of defendant appellant Michael Garcia. So it's respectfully submitted that the motion court erred in granting the East 23rd defendants motion for summary judgment in dismissing the claims against them for vicarious liability. As plaintiff's counsel argued, essentially the claim is that an intentional assault is not within the scope of employment. However, very importantly here, there has not been any determination that Mr. Garcia committed or is liable for that tort of intentional assault. There are numerous questions of fact regarding assault versus self-defense, as there is ample evidence that Mr. Garcia was acting purely in self-defense at the time of this incident. So therefore, some of the and that fact pattern distinguishes this case from several of the cases relied upon by the building defendants, where the employee defendant in those cases had been found to be the aggressor or had been found to have committed an unprovoked assault. There hasn't been that determination here. We also are in agreement with the Court of Appeals and the Ravello standard, which noted that this issue is a question best left for a jury, just due to the very necessarily fact-specific considerations and that the credibility of testimony, is going to come into play here. We would argue that Garcia's actions fall within the scope of his employment, as he was acting in a way that we believe could reasonably be found to be incidental and foreseeable, given the totality of the circumstances. The building is right next to a popular music venue. It's late at night. There's drunk, rowdy people, and that the overall safety and cleanliness of the building, meaning no urine, no broken glass, and a super who's not physically injured is arguably in the best interest of the building defendants.
So it's a very fact-dependent issue. Whether or not it's within the scope, and that should be before the finder of fact.
Correct. Yes, that is essentially our argument. He didn't violate any rule of his employer, any policy, because there was no such policy or instructions in place. So, yes, certainly the Hill affidavit, was an attempt to create an issue of fact. Mr. Garcia submitted an affidavit as well, stating that there hadn't been, any such policy that he violated. Further evidence of that is that he was not disciplined in any way by his employer following this incident. No dock and pay, no change to his living situation. When he left the building's employment, it was because his wife got a job in another state, and he was referred to numerous times in testimony as an exemplary employee. So,
Thank you.
thank you very much.
Good afternoon, Your Honors. May it please the Court, my name is Michael Reagan. I guess I'll first start out by just saying I don't think I need to spend much time on the negligent training, supervision, or hiring claims. Your Honors seem to have addressed that. I'll just say simply that the duty to investigate an employee or to institute specific procedures is only triggered when the employer knows or has reason to know the prospective employee's propensity to commit an act, there is no common law obligation to perform any type of pre-employment investigation. Also, as your honors know, he had been the superintendent of the building for, I think, 8 years at the point where the new owners took over, and then they simply took him over. Unless you have any further questions with regard to that particular claim, I'll move on. Okay, with regard to the adverse inference, again, just to get what's, I think, the quickest out of the way. The fact of the matter is, it's somewhat remarkable. You know, we have Mr. Mota and Mr. Garcia who give remarkably consistent testimony with regard to the facts of the accident. And then we have plaintiff's testimony, which is absolutely absurd and doesn't even make any sense. I mean, I'll leave that for your honors to look at. But telling is the fact that he was there with 7 other employees. He's had known Mr. Garcia since they were childhood friends. And then mysteriously, he deletes the information with regard to Mr. Garcia, all his contact information, can't testify to where he lives, doesn't know where he is. Now, counsel tells me that that doesn't mean that we couldn't conduct our own investigation. Well, this isn't part of the record. This is the horror of the record. But I will tell you that I did look into it, and there were 39
Mr.
Garcias in Pennsylvania. Okay, was it my obligation or our obligation to have an investigator go through each and every one of them? No, of course it wasn't. The fact of the matter is the adverse inference charge says when you have a witness and you would expect that witness to testify truthfully or to testify upon your behalf, and you don't produce that witness, you're allowed to infer that the testimony, in fact, would not be favorable. What more could be the case here? The fact of the matter is Mr. Mota testified very clearly, very explicitly, very directly. He also told the investigating investigators, the same thing. That plaintiff's friends were grabbing him, trying to pull him back and prevent him from going and confronting Mr. Garcia after they had initially been separated, and that this guy was a drunken yahoo, and he wasn't going to be stopped, and he was screaming and cursing and yelling, and he broke away from his friends, and he ran back across the street, and that's what happened. And that's why he deleted Frankie Rivera's phone number from his phone, because Frankie Rivera, in fact, would have corroborated my client's version of the events. Now, counsel talks about scope of employment, and they bring up 2 issues, the issue of the urination and the issue of this glass. Let's do the easy one.
He was on call 24 hours for any emergency.
Every building superintendent is on call 24 hours. Does that mean that every time one of them goes out into the street and punches someone in the face, the building is held liable for vicarious liability?
Well, no, but under Rivera and Ravello, we have to look to the time, place, and occasion of the incident, and the occasion was, by his own words, he was responsible for cleaning the building, he was trying to defend the building, he was acting in his capacity as super.
Respectfully, Your Honor, he never said he was trying to defend the building. That's what counsel said. That's not in the testimony. Let's go through them both, the urination and the defending the building. Let's do them separately. The urination had already taken place. The urination was 15 minutes earlier. What was he protecting the building?
Had taken place, but then he went inside, but then the person came back, and he said that he was concerned that the person was going to break the glass doors.
Yes,
that's why he said that he was involved in this altercation again, because he was trying to, whether you want to use the words defend the building or prevent the glass doors from being broken, that's why he said he was
Let's look at that. That's basically a justification defense. I think Your Honors would agree. Justification is in diversity of factual context. For a justification defense, you can't offer mere speculation and self-serving testimony. 2 things with regard to that issue. Number one, if just looking at the totality of the circumstances of the testimony of Mr. Mota as well as Mr. Garcia as to what type of altercation had taken place, the anger that took place. They got separated, they got pulled apart. He comes back in his building, he's fuming, and then he goes back out. A picture is worth 1,000 words, Your Honor. If you look at page 1030 in the record, you'll see, and the testimony is that they end up scuffling in the street in front of the bus stop next to the Gramercy Theater. Now, I don't have a ruler, but that looks to be 50, 100 feet from the building. 50 or 100 feet. And we're supposed to say that my client can be held liable as a matter of law for his conduct based on his self-serving testimony that he thought someone was going to throw something through the glass. When was there a threat to the glass? Did anybody threaten the glass? No, there wasn't anybody that threatened the glass. What is the testimony? Let's take the testimony of Mr. Moda.
Counsel, your time is up, so.
Can I just make one last point?
Yes, you
And
may.
that's this. Mr. Moda testified, after they got separated, he was hearing her screaming and yelling, and I quote, "I'm coming, it's over, I'm coming, I'm going to get you." He wasn't screaming, "I'm coming, I'm going to throw something through the front glass, through the glass of your building." This is a purely personal incident. It had nothing to do with my client. It had nothing to do with his job as a building superintendent.
Thank you.
Thank you.
With regards to the actions of Larry Kerr and Michael Garcia, this is one strictly factual. This was not personal. They didn't know each other. There were no grudges against the individual like the case law stated. This is a factual issue concerning whether it's an assault versus the actions of Michael Garcia being self-defense. And for those reasons, the lower court erred in granting summary judgment. Just going back to the point of Frankie Rivera, it's not Garcia, counsel never made any kind of demand to our office for any discovery on Frankie Rivera, and nor did he bring a motion concerning having an adverse inference charge, and brings this up as part of his motion for summary judgment. And for those reasons, that application should also be denied. If your honors don't have any further questions, then I'll rest on my papers.
Thank you.
Thank you.
Just in reply, counsel argues that this was a purely personal altercation, that Mr. Garcia's testimony was self-serving. We would argue that determinations are ones that should be made by a jury, that they can determine for themselves, what Mr. Garcia's motivations were, that's more proper for them rather than the lower court's judge. With regards to this motion. And again, taking into account the totality of the time and place and circumstances of this incident, that there's certainly a place to find that this was in furtherance of his duties as a building superintendent. And I would also just like to note that on behalf of Mr. Garcia, we are not contesting that part of the lower court's decision that dismissed the claims for negligent supervision and negligent hiring, as by all accounts, Mr. Garcia was a well-respected and liked employee with no incidents.
Thank you.
If you have any further questions.
No.
Okay,
Thank you all. Atlantic Mutual versus Greater New York Mutual. Judge Friedman is recused from this case. In the event of a tie, we will add another judge consistent with our rules.
Good afternoon, Your Honors. Eric Subin from Traub, Lieberman, Strauss, and Shrewsbury for the appellant, Greater New York Mutual Insurance Company. May it please the court. First of all, I'd like to apologize for my hoarseness. I'm not feeling very well today, and hopefully I'll be able to make myself heard. Before I begin my remarks, I'd like to mention a couple of recent developments that I hope will limit the scope of the issues before the court on this appeal. The first is that last week, counsel for the respondent, 40 East 80th Street Apartment Corporation, informed me that they're withdrawing the claim for coverage of the late fees that were awarded in the underlying action. So that issue had been briefed. I will not be addressing it in my remarks this afternoon. And second, I will not be addressing whether multiple GNY policy periods are implicated for the underlying claim. That issue is presently before the Supreme Court on GNY's motion to amend its answer to assert cross claims. And
So that issue's already before the trial court?
it's before the trial court, and I think it's better addressed there. And so GNY is withdrawing that issue from this appeal, the issue of potentially multiple policies being triggered.
Thank you.
Beyond that, this case really hinges on very basic concepts of insurance coverage law in New York. The GNY policy covers property damage caused by an occurrence, where an occurrence is defined as an accident including continuous or repeated exposure to substantially the same general harmful conditions. GNY does not dispute that there was property damage caused by an occurrence in this case, and in fact, GNY paid that portion of the underlying judgment that was specifically identified as being for property damage in the amount of $334,000 and change. I would add, and this is in our reply brief, that subsequent to that, GNY also did pay $1.8 million to settle the attorney's fee claim against the co-op under a reservation of rights, so as not to leave the co-op out swinging in the wind with respect to that issue, which was coming up for an inquest in Supreme Court. But as of now, GNY has paid over $2.1 million.
Getting to the issue of the property damage and what that entails, you said that you paid property damage, but we're talking about all the resulting loss of use of the property and the loss of use of tangible property. What is has anything been paid on that aspect?
No, and the answer, and the reason is, and this.
So the question is whether that should be part of whatever is paid, whether that too is damage that should be covered.
Our argument is that it's not damage that should be covered because it's not damage because of property damage. It's damage because of the proprietary lease and the real property law. And the violations of the proprietary lease that were alleged in the underlying action, which were found to have occurred, are not an occurrence under the policy wording of the GNY policy or under New York law. And the cases that the co-op has cited in response or in opposition.
The provision, sorry to interrupt you, but you're legally obligated to pay as damages because of property damage. So why don't these other consequential damages qualify?
Well, if I may, because all of them flow from, if I could put it bluntly, they're not because of property damage. They're because of a breach of the proprietary.
Would they have happened but for the water damage in the apartment? No.
Okay,
I'll answer my own question.
Okay, but if the suit were just for water damage in the apartment, they couldn't get attorney's fees. They couldn't get rent abatement. They couldn't get alternate living expenses. Those are not tort damages for property damage, which is what's covered under a CGL policy like the GNY policy. Those are remedies that are specified in the proprietary lease and the real property law, especially with respect to the attorney's fees. You don't get attorney's fees if you sue your co-op because you had property damage, unless there's well, if you sue your co-op, if there's a proprietary lease, you could, but you don't get, if you just had property damage in your house because a contractor put the roof on wrong, you're not getting attorney's fees for that unless you had a contract that said you get them. So you're not getting them because of the property damage, you're getting them because of the contract.
Sir, wouldn't it have been an easy matter for the insurer to exclude certain sums from the coverage instead of broadly casting it, as Justice Moulton mentioned, pay those sums that the co-op becomes legally obligated to pay as damages?
Well, I would say that the cases do not, well, as I understand the case law, it doesn't require an exclusion in that regard because it's not in the insuring agreement in the first instance. It's not an occurrence to breach a lease or a contract of any kind. And so since the insuring agreement requires an occurrence to trigger coverage and the breach of contract is not in itself an occurrence, you don't need to exclude it. It's just not within the scope of coverage in the first instance.
Thank you.
Thank you.
Good afternoon. May it please the court, Jay Dealey from Pillsbury, Winthrop, Shaw, Pittman on behalf of Respondent 40 East 80 Apartment Corporation, or the co-op. On the issue of indemnity for the elements of the Baker judgment that are issued, the alternate living expenses, the rent abatement, and the attorney's fees, Supreme Court correctly found that these were all damages that the co-op became legally obligated to pay because of property damage. And so they are all covered under the policy. And this court's decision in Hotel des Artistes squarely rejects the argument that GNY is making here. In Hotel des Artistes, there were only contract claims that were asserted. A restaurant's premises were damaged by a fire, and they sued the hotel for repairs because of the fire, for breach of lease. And this court held that the insurer was obligated to defend the hotel because there was potential coverage for those contract claims. This court expressly rejected the argument that damages for breach of contract are not covered. This court explained that the insurer agreed to indemnify and defend the hotel for all sums the hotel became legally obligated to pay as damages because of property damage without any limitation or restriction as to the source of legal obligation. There is no requirement that the hotel engage in negligent conduct, commit any other tort, or even be at fault for the property damage so long as it is legally obligated to pay for it. And that is at 983rd 192. That is exactly the situation that we have here, although here there is also a negligence claim. But the policy contains the same language regarding damages that the insured is legally obligated to pay because of property damage, and there was no exclusion for a breach of contract.
Counsel, just to confirm, late fees are off the table, right?
Correct. Yes, they're a de minimis amount, and we're not pursuing those. GNY argues that breach of contract is not an occurrence, but that is not what the co-op argued, and it's not what the Supreme Court found. We have an occurrence here. They've admitted there's an occurrence because they paid for the repair costs, right? The occurrence was the water infiltration that caused the property damage. And there's an issue as to how many occurrences, which is currently before the Supreme Court. But all of this was because of property damage caused by the water infiltration. And the Hotel des Artistes, this court distinguished the contract cases that GNY is relying on, which are cases involving when a contractor is hired and it negligently performs the work and gets sued for not delivering what it promised to deliver. Those breach of contract damages aren't covered. But that's not what we have here. Here we have damage to the baker's apartment caused by the water infiltration. So those cases clearly do not apply. As to the alternative living expenses, GNY argues that that's not the proper measure for diminished value, but that's a red herring. So the cases that GNY cites involve trespass or nuisance where the property owner never left the premises and never sought alternate living expenses. Here, alternate living expenses are a cost that the bakers incurred and had to pay because they were unable to use their apartment because of repairs for the water damage. So those are out-of-pocket expenses. They're frequently awarded in property damage cases, such as the judgment this court affirmed in 2021, Shaw v. 20 East 64th Street, LLC. That's 198 83rd 23. And finally, the attorney's fees. The attorney's fees here were awarded because of the property damage. And this court's decision in XL Specialty is instructive. GNY distinguishes XL Specialty because that involved a securities claim. But the point is that coverage was triggered there. There was a wrongful act that triggered coverage, and because of that, and in connection with that wrongful act, the attorney's fees were awarded. Here, coverage was triggered, again, because of an occurrence, property damage caused by the water infiltration, and the attorney's fees were awarded because of that damage. And finally, there's an independent reason, an independent basis for awarding attorney's fees in this case, which is the supplementary payments provision, which provides that the insurer will pay for cost tax against the insured. And GNY argues that costs should be interpreted in the policy to be synonymous with costs under CPLR Articles 82, but there's nothing in the policy that so restricts it. And in fact, in the 2009 policy, GNY expressly excluded attorney's fees, but it did not do so in any of the prior policies. Thank you.
Thank you.
Briefly, Your Honors, I'd just like to address some of the case law that my learned opponent just discussed. But first, I'd just like to say once again, GNY did defend the co-op in this case. And the really singular distinction of the case law that Mr. Jean was discussing is that they were duty to defend cases. They were not overall duty to indemnify cases. So in Hotel des Artistes, for instance, on page 192, the court stated, finally, we reject the hotel's argument that as a consequence of GAIC's wrongful breach of its duty to defend, GAIC is required to indemnify the hotel for the entire amount of the settlement in the underlying action without regard to whether the entire sum relates to covered losses. So the court was keeping its powder dry with respect to there was actually going to be coverage at the end of the day for those contractual claims that were asserted in the suit. Similarly, in XL Specialty, the court stated, the award of attorney fees is typical in a derivative suit where the plaintiff prevailed. The underlying action here was not a derivative suit, and the award of attorney's fees is not typical in claims for property damage caused by an occurrence. And I would also mention that I can't think of any interpretation of the supplementary payments language in the GNY policy that would lead to the conclusion that the phrase cost, as commonly understood, includes attorney's fees. And with that, unless the court has any further questions, I will rest.
Thank you.
Thank you.
Thank you both. An-LYH Investments versus JDS Principal.
Good afternoon, Your Honors, and may it please the Court. My name is Adrienne Koch from Katsky Korins, and I'm here on behalf of the defendants' appellants. The plaintiff is the beneficiary of a $1.5 million promissory note given by defendant JDS Principal Highline. That defendant hasn't moved to dismiss the claim against it under the note, and it's not a party to this appeal. This appeal is addressed only to the plaintiff's efforts to recover that same $1.5 million from the other two defendants, JDS Construction and Michael Stern. With that in mind, I want to start with the claim against Mr. Stern. The plaintiff's claim, as described in its briefing, is that it has an oral loan agreement with Mr. Stern that makes him jointly and severally liable for the same $1.5 million.
The note doesn't talk about that, obviously. It's an oral agreement.
Correct.
And the note talks about any other agreement which would modify or affect the note.
Correct.
So would this affect the note? Seems like it would.
Absolutely, it would, Your Honor. And in fact, the note says that there's no other agreement that would modify or affect its terms, and it also says that any modification of the note must be in a signed writing. And under the general obligations law, an agreement that something other than payment on the note itself would erode we call it JDS Highline. Any agreement that something other than payment on the note itself would erode JDS Highline's liability would have to be in writing because that constitutes a modification.
So can we agree that basically the claim for breach of oral loan agreement essentially would add a co-obligor or joint obligor to the promissory note?
I'm not sure if I understand your question. If you're saying they seem to be claiming that they had an oral loan agreement with Mr. Stern that essentially made him jointly and severally liable for the same $1.5 million that the note covers. So yes, co-obligor.
Okay.
Correct.
And so how would the presence of in deference to me, we'll say, co-obligor, modify or affect the promissory note?
So if I can answer your question by taking a step back for a second, everyone agrees that the statute of frauds would bar any claim that Mr. Stern orally agreed to make payments against the note, because that would be an unwritten obligation to answer for the debt of another. The note obligates JDS Highline. If you had an oral agreement by Mr. Stern to make payments...
What if it's a separate agreement?
If it's a what?
If it's a separate agreement.
If it's oral, it's barred by the statute of frauds. And if you could get around that prohibition by simply claiming that what Mr. Stern agreed to do instead was be jointly and severally liable for that same $1.5 million that the note obligates JDS Highline to pay, the prohibition in the statute of frauds wouldn't mean anything. And you'd be opening the floodgates to litigation claiming such oral agreements left, right, and center. That's exactly what the statute of frauds exists to prevent.
Unless, as Justice Cohen pointed out, the merger clause had contained language that the promissory note superseded any other agreements.
Well, Your Honor, there are two different things here. There are two different problems that the plaintiff's claim suffers from. One is the statute of frauds, and the other is the language of the note itself. If the alleged oral agreement was an agreement by Mr. Stern to make payments against the note, that's barred by the statute of frauds. But if it was an agreement that Mr. Stern would make payments against some separate obligation that's his own obligation, but those payments would erode JDS Highline's liability, which is what the plaintiff says the agreement was.
Stern paid, would JDS Highline have to pay?
No, that will under the agreement, the oral agreement, as the plaintiff describes it in its complaint, if Mr. Stern had paid under that alleged oral loan, then that would erode JDS Highline's liability under the note, and that is exactly what makes this alleged oral agreement violate the terms of the note, because that would be
erode a synonym for effect?
Affect, reduce, that would be effect, yes. But the general obligations law is clear that if you have a provision that says an agreement cannot be modified except in a writing, an agreement to erode the liability is a modification that has to be in writing. So either way, the oral agreement cannot satisfy the terms of the note. They have not come up with any version of this agreement that doesn't violate either the statute of frauds or the terms of the note. I see that my time is up. I didn't have a chance to address the claim against JDS Construction, but perhaps if the court has questions. I apologize?
I'll give you I'll say 30 seconds. I said another
Right now?
minute, but yes.
Okay, thank you. Thank you, Your Honor. So the claims against JDS Construction, there are two of them, one for unjust enrichment and one for money had and received. Our brief details various defects in each of those claims, but I'd like to focus on the one defect that's common to both of them, which is that there is a written contract, namely the note, that covers the subject matter of these claims, namely the $1.5 million obligation. And the fact here again is that the $1.5 million that the plaintiff is trying to collect from JDS Construction on these two claims is the same $1.5 million that is the subject of the note. And the note undisputedly obligates JDS Highline, not JDS Construction, to pay that money. And yes, it's true that where there's a dispute over the existence of a contract or its scope, you can have a quasi-contract claim in the alternative. But that principle doesn't apply where there is at least one contract whose existence and validity is undisputed. And that's so even if there's a dispute about whether there are other contracts, and even if the quasi-contract claim is asserted against someone who isn't a party to any contract. That's clear from the case law that's discussed in our brief. And the subject matter is the same. It's the $1.5 million. If you could get around this principle by defining the subject matter to include only the things that the contract specifically addresses, the principle wouldn't mean anything. It doesn't work that way, and that's clear from the case law discussed in our briefing as well. Unless the court has questions, I'll save for rebuttal. Thank you.
Thank you.
Thank you. Let me start with the statute of frauds. It is disputed that the statute of fraud applies, the statute of frauds, excuse me. They rely on a suretyship provision of the statute of frauds, but this is not a suretyship relationship. It's alleged to be a joint and several obligation. If you look to the note, there's an anti-suretyship provision. It says that it is a principal obligation, not a suretyship relationship. Now, why would that provision be in there? I mean, their central theory is that the promissory note is actually a loan agreement, and it's the exclusive loan agreement. There is no other. This was not an integrated transaction. Well, if that's true, as we all know, contract interpretation, no language should be superfluous.
Stern paid the loan. Would JDS Highline have to pay the loan?
No, it is a joint and several obligation. So consistent with how the majority of commercial loans in this state work, there is a loan agreement and a promissory note, joint and several.
Isn't that an effect? Isn't that affecting the promissory note?
It's not. So as far as merger clauses go,
Payment isn't an effect?
No, it doesn't affect the note. This is part of an integrated transaction where it needs to be read as a whole. So the normal, way that this is done is there's an express loan agreement and the promissory note is appended to the loan agreement. It's a joint and several obligation that makes the maker obligated on the principal debt, and it's joint and several. What this merger clause does, and it's incredibly narrow if you look at it, we all know what the magic language is. If you want a broad merger clause, you say there are no other agreements at all with respect to the subject matter of this document. That's not what this says. This says there will be no oral modifications to this note. What does a note do? A note obligates the maker to pay. It doesn't recite what the background of the loan is. It doesn't say this is the exclusive loan obligation. They could have written that in there. That's not what they did because that's not what notes normally do. It is the note that is usually ancillary to a loan agreement, and that's exactly what we have here. The only difference being is that the loan agreement, and I admit, is not the case in a majority of situations, but the loan agreement here is oral. There is no statute of frauds provision which prevents the enforcement of a loan agreement that can be performed under a year. This was a 5-month loan obligation, so it could have been performed under a year.
Sir, I think I think you're making some very good points, but I am troubled as Justice Friedman asked your friend this, and he just asked you this, and I'm still not sure I understand it. If Stern pays, how does that not affect, the magic word, right? Affect the terms of the note?
Well, the loan agreement is not alleged in the complaint to vary the terms of repayment or any term under the note. So it doesn't vary the terms of the note. We're not relying on an oral agreement that varies the term. In a sense,
Just affects it.
well, the actual payment affects it, but what the loan obligation is only, it's a joint and several obligation because it's part of an integrated agreement. So the actual obligation itself is to repay to the extent not paid by the joint and several principal obligor.
What you're saying here is we have an oral agreement, pay me on the oral agreement. And after you pay me, this written agreement goes away. It's hard to think of anything which has more of an effect on something.
Well, again, I view this as an integrated transaction, okay? Because it is 2 documents executed at the same time.
A verbal
covering the
agreement
same
in a
transaction.
document.
That's right. Executed in the sense that it was verbally executed, verbal and through conduct, and along with the execution of the affiliate to make it clear that the affiliate also had an obligation to repay. So just like all agreements, and yes, there's one written and one oral, and that makes this unique. But just like all agreements, you must interpret them, and this, of course, is subject to us proving through discovery, but taking the allegations as true, we're at the dismissal stage here, you must interpret them so as not to invalidate the others.
Why no reference to the oral agreement?
Is there a reference?
I mean, because you mentioned that they were integrated transactions.
Yeah.
Why no reference to the oral agreement in the written agreement if they're integrated?
Yeah, so I suggest that there is an indirect reference to it in the statement of suretyship. Why are they specifying that it's a principal liability instead of a suretyship liability if this was the only loan agreement? If the promissory note was intended to be the entire loan agreement and it was just with JDS Highline, why would you be mentioning suretyship at all? Suretyships involve 2 people. So if you're specifying that it's principal instead of suretyship, that presupposes that there was 2 involved. The promissory note is a simple promissory note. as Justice Cohn said. So it doesn't specify a lot of things. It doesn't give any of the background of this loan. It doesn't say who the actual borrower is. Would it have been better if they were explicit? Yes. But that doesn't mean that it forecloses the possibility of an oral agreement, particularly with a narrow merger clause like this. Thank you.
Thank you.
Thank you.
Counsel, how do you respond to your friend's suretyship argument?
You mean the language in the note that says that this is that is a principal and not a surety?
His arguments regarding surety.
Okay, so a couple of things. First of all, as to the language in the note that says the maker executes as a principal and not a surety, that's boilerplate. That's the sort of thing you find in every note, and what, as far as our argument that this is an integrated transaction, in every single case that the plaintiff cites in support of that argument, that there can be more than one primary obligor on an integrated loan transaction, every obligor was a party to a written agreement. The plaintiff hasn't cited a single case where one party's obligation was reduced to a writing and another party was found liable as a co-principal based on an oral agreement. And in fact, that's exactly the sort of argument that this court rejected only a couple of months ago in the Tokayer case, where someone was claiming that a non-party to an agreement made an oral promise to be jointly and severally liable, and that created an original and primary obligation. And this court held that it was an agreement to answer for the debt of another, and it was barred by the statute of frauds. It's not about suretyship only. Any oral agreement that says that I am going to pay an obligation that a written agreement obligates someone else to pay is void under the statute of frauds.
And this specifically says that there are no verbal agreements.
It specifically says that, and that, Your Honor, is also fatal, I respectfully submit, to their integrated loan transaction argument, because the parties to integrated loan transactions have written agreements with everyone that refer to each other. They do not have documents that say in black and white on page 111 of the record that there are no other agreements that affect its terms. That's the opposite of being part of an integrated loan agreement that involved other obligors whose payments could satisfy liability under the note. I see that my time, once again, is up, so unless the panel has further questions.
Thank you.
Thank you, Your Honors.
Thank you all. Ovid and Ovid versus Google.
Good afternoon, Your Honors, and may it please the Court. Andrew Kincaid of Ovid and Ovid LLP on behalf of Appellant. The lower court erred in denying Appellant's action for pre-litigation discovery pursuant to CPLR 3102C for two reasons. First, the lower court incorrectly held that the bogus review is a matter of quote-unquote pure opinion rather than mixed opinion and fact or pure fact. And second, the lower court incorrectly held that the bogus review is not, quote, defamation per se. Even
what does rude attorney even mean? That's one of the statements.
Respectfully, Your Honor.
They have rude attorneys. I mean, what is that?
Your Honor,
it's an opinion. It seems solidly an opinion. It doesn't, I mean, also it's a little amorphous.
Your Honor, if the review were just quote unquote rude attorneys, I would be forced to agree with you. Unfortunately, the review is much more extensive.
With high amounts of censorship as the remainder. So that somehow bolsters rude attorneys?
Your Honor, yes. In fact, that's a factual allegation, or at this pleading stage, must be interpreted in the light most favorable to appellant.
Which would be
what? Does that even mean?
That Your Honor, the dictionary definition of censor as set forth in our papers.
Or rude, let's start with that one.
Rude, Your Honor, I agree, is a matter of opinion. Here it reflects the fact that there's an implication that the postor, the reviewer, had an interaction or is alleging
Okay, so
something.
you've already said you agreed that rude is an opinion, so then you were getting onto censorship, so go ahead.
Standing alone, Your Honor, rude is a matter of opinion, I agree. With respect to censorship, the definition set forth in our papers, including in Merriam-Webster, among others, includes the suppression of information, and that is specifically what is prohibited by Rule 3.4 of the Rules of Professional Conduct.
But what, I mean, okay, attorneys aren't supposed to share attorney-client privilege. They're not supposed to share a work product, so they're censoring themselves and not providing that information. Could this speaker, whoever it was on the internet, have been talking about that?
That's a potential interpretation, Your Honor. However, at the pleading stage, we are entitled to the interpretation most favorable to appellant, and I would take the example of the case, the Flam case cited in both our papers. There, the Directory of Attorneys referred to the attorney in question as a, quote, ambulance chaser, end quote, who only took, quote, slam dunk cases, end quote. And that was found to be defamatory because—
The ambulance chase has a derogatory attachment to it.
Your Honor, I've never heard censorship used in a positive way, and our papers are replete with examples, including from recent media posts.
I'm not gonna say that it's used in a positive way, but it's just like very ambiguous. You don't know what it means here.
I don't think it's ambiguous at all, Your Honors. Censorship always means to suppress something.
But rude always means somebody who's going to say something that's, you know, it's not a positive thing either. I mean,
Certainly,
to
but that turns to the
that
question
end,
of whether—
neither is positive.
Apologies, Your Honor.
But the question is whether there's some precise meaning, whether in the context here you get some precise meaning of what is going on. Somebody who's rude and high amounts of censorship. What does that mean with high amounts? That doesn't even sound like English. High amounts of censorship. I mean,
I can't account for the grammar, Your Honor. However—
it sounds like slang is what I mean. And then it's not really what censorship means. I don't even know what that means if now we're talking about slang.
Respectfully, Your Honor, the court in Flam similarly rejected the argument that the person in question must use the precise dictionary definition of a term for it to be defamatory. Again, ambulance chaser, while perhaps common parlance among attorneys, isn't a legal phrase, yet the court there found that it was sufficiently precise and was sufficiently susceptible to a defamatory meaning.
Doesn't the alleged defamatory words have to be sufficiently concrete that we could analyze whether they're objectively true or false?
And Your Honor, if we were at an evidentiary hearing, we could prove true or false whether or not appellant has engaged in quote-unquote censorship, whether or not somebody has suppressed evidence, whether or not there has been an act of discandor toward the tribunal in violation of Rule 3.3 and 3.4 for the failure to disclose evidence. Those are sufficiently concrete facts that somebody could prove at an evidentiary hearing happened or did not. At the pleading stage, we've established that there is a reasonable interpretation that is defamatory. The fact that there's other possible interpretations that might be slang or that might be non-defamatory does not defeat, at the motion to dismiss stage, the petition. I see my time's elapsed if Your Honors have further questions.
Thank you.
May it please the court, I'm Michael Houston of Perkins Coie on behalf of the defendant respondent, Google. This court in Sandals Resorts wisely recognized that corporations should not be permitted to use court orders to silence critics of their business on the internet. That's exactly what Ovid is here trying to do.
He says, counsel says that censorship is only used in negative ways and that it relates to documents and the suppression of documents.
So, Your Honor, I think with regard to—
Does that make it, yeah, does that take it out of the realm of non-defamatory?
No, of course not, Your Honor, for exactly the reason that I think the premise of Your Honor's question to my friend suggested. Rude is always a negative term. Nobody's ever heard of somebody who, you never call someone rude in a positive way, but calling someone rude is almost the quintessential form of opinion, and that's why the cases saying that calling someone rude is not actionable as a matter of defamation law are legion. My friend hasn't cited a single case in his papers where any court Court has found that calling someone rude is an actionable statement of opinion. And I heard my friend concede today that it's not actionable. So with regard to censorship.
Well, it's rude coupled with censorship.
Yes, Your Honor, that's right. You have to review the whole 9-word review in context. Ovid's attorneys has rude attorneys and high amounts of censorship. I think the important point is to understand who the standard by which that is judged is the average reader, as this court said in Dillon. So while my friend wants you to say, look, we could sort of engage in a lawyerly exercise where we can get to a place where you can kind of sort of squint and see how you could construe one of the rules of professional responsibility that governs attorneys as a matter having something to do with censorship. And quite honestly, I'm not even sure I can get there as an attorney who actually has those ethical responsibilities, but I certainly submit to you that the average reader of the Google Maps platform is not going to be able to hear the statement, Ovid's attorneys have high amounts of censorship, and trigger in their mind, this has something to do with the rules of professional responsibility on attorneys that relate to the suppression of evidence. The average reader won't draw that connection. That's why merely saying that you can imagine a way that the review could be defamatory doesn't carry the day here. You look at what an average reasonable reader would think about. It's important, I think, also to keep in mind, I heard my friend reference the Flam case about an ambulance chaser. The court's holdings have been consistent that when you're analyzing whether something is a statement of fact that is provably false or a statement of opinion, the context matters. Contrast the Flam case with the Feinberg case discussed in our brief, also referred to as an attorney as, quote, the statement of the review there was, ambulance chaser is too good a term for him. Feinberg is on a Yelp review of a business. The Flam case that my friend relies on is in a published attorney directory by a reputable organization. Why was Flam held actionable and Feinberg wasn't? It's because of that context. And this court has made clear over and over again that regular readers understand that on the internet, customer reviews, the kinds of things that you find on Yelp, are characterized by a sort of freewheeling style, by slang, by hyperbole. These are not like the kind of factual, and people understand that somebody's one-star review on a business doesn't come with the same type of factual backing that a New York Times article does. That's this court's holding in Sandals, in Tarati. That's the Mirza case from the Eastern District of New York. It's Feinberg. That's the core lesson of all those cases, that this online context of reviews is, you should be skeptical that those types of comments will be defamatory. And it's really important that we have that skepticism because there are First Amendment values at stake here.
Counsel, I know that's been said in a number of cases, but I also feel like the public can be incredibly credulous about what is on the internet. And is there data that supports that assertion that people take with a grain of salt, online reviews? Well, is there data on that?
I mean, there were studies and there were papers that were written about this issue that were cited favorably by this court in Tarati and in Sandals. I mean, I can't point you to more authority.
Fine. I can look it up.
I can't point you to more authority than that. I think it's also just an intuition about who is the average reader of the Google Maps platform. What do they know? What do they think about when they read a review? And again, I think the critically important point that I'd like to leave your honors with today is when you go to a restaurant and you have a bad experience and you want to write on Yelp, don't go there. The chicken is overcooked. That's an opinion. It's not a provably false statement of fact. And it's important that you be able to make that post and share that post with other customers and other users without fearing that the restaurant is going to sue you for defamation. The same principle forecloses Ovid's claims here. Thank you.
Thank you, Your Honors. A few points. First, the Sandals case is readily distinguishable from the facts here. There, a apparently disgruntled reviewer sent a large email chain to regarding the Sandals Resort in Jamaica, insinuating issues with their hiring practices and racial discrimination, and included, among other things, numerous links to articles, citations, and primarily asked rhetorical questions rather than making accusations. In that context, providing links for the basis for their opinion, this court and courts throughout New York have repeatedly said that is protected opinion because you've told me why you think that. He engages in high degrees of censorship because here is a link to whatever I think he did. Now you can understand from where I drew my opinion. That is protected. Likewise, the Feinberg case is in a long cite in Google's brief with a bunch of other decisions where there's fanciful or otherwise outrageous language that gives context to the review and makes clear that the person writing it might not be taken seriously. For example, there's a Robin Williams SNL sketch. The review in Feinberg goes on for a while to say, if you can't find any other attorney, take this guy, he's the worst, or something to that effect. In that context, it is clear the person writing it is going over the top or being fanciful and not making an allegation of fact in the same way that here there is no such adornment that might occasion a person to think, oh, this person's being hyperbolic, this person's being silly. And with respect to Your Honor's question about the data regarding online reviews, I'll refer this court to the Santos court, which cited only a 2002 law review article for the proposition that the internet is the contemporary public square or what have you, and that we should respect freewheeling discourse. I'd respectfully submit the times have changed substantially.
That was when we were back on Prodigy.
Pardon?
Never mind. In other words, that was the infancy of the internet.
Right, we were on Lycos and Hotbot at that point, not Google. And the world has changed substantially. People take what they see online substantially more seriously than they did 22 years ago. And pretending otherwise, I think, is irresponsible. Thank you, Your Honors.
Thank you. Thank you both. United Hay versus Heronian.
Good afternoon, Your Honors. May it please the court, my name is Todd Steckler, and I represent Jacob Heronian, the 97-year-old father of Mark Heronian, who is the managing member of United Hay, the entity that's suing here. This case is part of a much larger family dispute involving hundreds of millions of real property here in New York City. This particular case involves $5 million that Jacob removed from the United Hay bank account pursuant to his authorization as a signatory on that bank account.
Right? Your client is not a member of United Hay?
My client is not a member of United Hay. That's correct, Your Honor.
In a different case.
He is not a member of United Hay. That's correct.
So then does he have the authority to remove the money if he's not a member of the?
He was on the bank account and had signatory authority to remove money, to act as a signatory on the bank account. And there's no question about that.
Does being a signatory mean that you have authority to just take money out as you please?
Apparently, yes, that is what that means.
I mean, that's what you want us to hold.
I'm sorry, Your Honor?
That is what you want us to hold here.
No, Your Honor, I don't need to get to that point because I don't think that Jacob needs to justify his actions here. I think the issue here is the admission against interest by United Hay that prevents them from meeting the standards to create a prima facie case for conversion here. And that occurs as follows. Mark was sued by his sister. As a result of that, for stealing money from the companies, from the family LLCs. As a result of that, Mark went and redid the tax returns for the family LLCs, including United Hay. And when the tax return for United Hay was redone, amended for the first time, they changed the $5 million that Jacob got from an exchange, which is exactly what it says, I give you something, you give me something back, to a distribution. The case is commenced after it's a distribution to sue Jacob. Jacob decides to move for summary judgment based on tax estoppel because they had represented that it was a distribution and therefore it couldn't be a conversion. After hearing the basis for Jacob's motion for summary judgment, United Hay re-amends their tax return. This is after the case is commenced and realizing that they made a mistake in the first amended tax return.
Did we already reject this argument, though, at least sub silentio, since you guys have been up here once before?
Once before. That was on the tax estoppel argument on distribution, Your Honor.
Right.
This is a different theory based on an admission against interest. So what happens is they re-amend, okay? And instead of calling the $5 million a conversion, they discuss it with each other. In fact, there are emails going back and forth between them saying, how are we going to do this? How are we going to treat this? And this is what they end up saying. They say, the original tax return of the partnership reported the $5 million paid to Jacob as an exchange involving the transfer of cash to Jacob in return for his undertaking to return assets to the trust having equal or greater value. That admission against interest comes after this case is commenced and is contrary to the claim of conversion here. That is, they can't prove that Jacob is holding this money contrary to their interest because they've now admitted that they've given the money to Jacob. They paid it to him and they transferred it to him. That admission against interest is fatal to their conversion claim. The elements of the conversion claim are really quite simple. The first is, does he have authorization to act? The answer to that is yes, he had authorization to act. He was a signatory on the bank account. His right to act was taken away from him after he took the $5 million. There's a letter to the bank that we provided saying, we've taken away your right to be a signatory on this account. The court set a new standard. They said, it's only if you have a legitimate purpose that you're authorized to remove money. But there's nothing anywhere that talks about legitimate purpose, not in the law, not in his rights, in nothing. The second is dominion and control.
So he could have used it to pay his bookie? I mean, what?
He could have.
Anything. He could have used it for any purpose.
And they could have sued him to get the money back, but not as a conversion. It's a theft. They could have gone to the police and said, you stole the money. But it doesn't make out a conversion under civil law here. The admission also prevents the second category, dominion and control of plaintiff's property. They admit, after this case is commenced, in the second amended tax return, that they paid this and transferred this money to Jacob. They don't say Jacob stole the money. They don't make any claim about that whatsoever. They say they paid it and transferred it to Jacob.
Right, and they've asked for it back since then.
No, they never asked for it back, Your Honor. That's the other point. The only time that there was possibly a request to ask for it back was a letter from Mark to his father, where he says, I hope you find it in yourself to return the funds. That's the only time there's any statement of any kind about returning the funds or a demand of any kind. In fact, the subsequent letters even talk about Jacob keeping the money before this lawsuit is started.
Thank you.
Thank you.
Good afternoon, and may it please the court. William Sharon from Prior Cashman for Plaintiff Respondent United Hay. Justice Moulton, you're quite correct. We have been through this before. The tax estoppel defense was dismissed. This court affirmed. Justice Cohen rightly pointed out that this argument that you're hearing now, which my friend, I think, candidly acknowledged, is a new thought that they've had that is a variation on the same tax estoppel theme that's already been thrown out. He's going to try this now instead. In doing so, he keeps, the appellant keeps quoting a part of the record, page 850, which is the amended tax return. What he keeps ignoring is the rest of that very language, literally the next sentence that says, litigation exists between the partnership and Jacob Heronian for the return of the $5 million taken from the partnership by Jacob Heronian. For the same reasons, this court previously found that other language that they were focused on previously about distribution did not constitute an estoppel, did not constitute an intentional relinquishment of a known right or a waiver based on the same language. It still applies here. The recitation of the facts is significantly incomplete. It's all in our papers, it's all in the record, but in some, Jacob Heronian in December of 2014, knowing that his son, the manager, was out of the country, went to the bank and took the money. He admitted it. He's quote, I decided and I went and it's in my custody. The money's in my custody. According to him, I'm the father, everything belongs to me. So he just took it, as Justice Cohen properly found. without any justification. A bank account signatory authority does not constitute a license to steal. That is exactly what they're asking this court to hold. That's
Wasn't
not
the
right.
inquiry who has the superior interest?
The superior interest obviously belongs to United Hay because it was in United Hay's bank account. Jacob admits he's not a member. Jacob admits he's not a manager. Jacob admits he has no authority. Jacob's whole argument is that a part of an amended tax return statement shows that, well, United Hay obviously meant to give me this money, except I admit that I took it in the dead of night. I admit it wasn't supposed to be given to me. I took it because I'm the father. I admit I took it for all sorts of reasons, that he wanted his wife to have it or whatever else. And none of that, Justice Cohen described this as, described his arguments as, quote, a strange planet and through the looking glass kind of stuff. It's at record 35 and 37. I submit that Justice Cohen was being generous in those descriptions. This has gone on for years, where he has been taking these linguistic, kind of gamesman-like arguments that has kept going for years. This case has a 2017 index number, and we've had to fight for through his summary judgment argument, which was the same argument that you're hearing now. He lost it. He didn't appeal. We had to fight through the defenses. His defenses were all dismissed and affirmed by this court. And now we're back after Justice Cohen said, this is not a complicated set of facts. The money was taken without justification and has been retained despite requests for it to be returned. There's absolutely no legal justification for the withdrawal of the funds. I will just also note that the demand is at record page 125. It says, again, it's selectively quoted. Mark wrote to his father, what you did was not proper. I did not and do not agree with it. He talks about, I want you to return the funds. What he leaves out is that this was all happening in 2015 while they were trying to settle.
Thank you, counsel.
Thank you, Your Honors.
The trial court conflated the idea of estoppel and admission against interest here. Estoppel is a legal concept. Admission against interest is a factual concept. They don't know how to overcome the facts. They could have submitted an affidavit from the tax lawyer who wrote this, who said, I made a mistake. They could have submitted an affidavit from Mark saying, oh, when we were trying to do this, we made a mistake. There's nothing rebutting this admission anywhere. And when you make an admission like this without a rebuttal, it means that you probably believe the admission is true. And that's the exact point we're talking about here. We didn't get a chance to do discovery here. We were cut off just as we were about to move here. The only discovery we got were these two emails where they talk about the fact that they're trying to figure out how to treat this $5 million on the second amended tax return. And this is what they decided on. They decided they were going to say that it was paid to Jacob as a transfer. That's their admission. It's there. They can't get around that admission against interest, and they've never tried to get around that admission against interest. They simply have said, it's estoppel. Estoppel's been dismissed. You can't do it. Thank you very much, Your Honors.
Thank you both. Intrepid Investments versus Selling Source.
Thank you, Your Honors. Mark Hatchmiller from Sussman Godfrey for the defendant Selling Source. This case is about a third priority lender that has repeatedly, this is now the second time, filed premature lawsuits to try to enforce its junior debt instrument ahead of Selling Source's senior creditors, including White Oak, who's represented here by separate counsel, on a different motion to dismiss. This case is the plaintiff's second attempt to jump the line in violation of the clear terms of a standard issue intercreditor agreement, and the case should have been rejected at the outset, including based on res judicata principles, as well as for insufficient pleading, as my colleague will address. The same creditor plaintiff, Intrepid, filed another debt enforcement case in violation of the lawsuit bar back in 2013. That case took almost 7 years to resolve, despite the fact that it was filed in violation of a intercreditor agreement that was not even mentioned in the plaintiff's case at the outset, we had to address it through an affirmative defense. And Intrepid used that case as a fishing expedition to seek extensive discovery, to try to find a justification to jump ahead of the line. It didn't succeed. Over the course of the case...
I mean, the question on res judicata is whether your amended answer, the grantor's amended answer, was in front of the court.
Correct. And
you say it was, obviously.
Exactly.
But I'm not so sure. Explain to me why it was.
So, the amended answer was permitted over Intrepid's repeated objection. The reason we filed the amended answer is because after, at that point, 5 years of litigation with the case still unresolved, we wanted to show that the senior debt had still not been paid at that point. So a lawsuit would have still been premature. And the court, which was at that time Justice Branston, ordered a disclosure of the documents proving the existence of the senior debt. We produced the documents showing all the payments that had been made to date to establish our defense, and then she granted a motion to amend.
Can I just ask you, right now, what's happening is that White Oak is attempting to show that this was paid in full by January 31st, 2019. That's the new claim. That couldn't be precluded.
Intrepid is the plaintiff, and White Oak is the senior lender.
Yes.
Their complaint states January 1st, 2019. But we filed, because it's ambiguous as to what payments they're talking about, we filed a motion, we sought a bill of particulars to specify what payments were at issue. And although Intrepid tried to dodge answering the question directly, it became clear subsequently, and it's no longer disputed, that the transactions at issue are the same ones that were disclosed through discovery in the 2013 case. And because we wanted to make sure we would not face a second lawsuit, a new attempt to spend years more litigating over the same issues, we sought permission to amend. Justice Branston granted the motion. There was an oral request at a hearing, which is in the record, to strike the answer. Justice Branston declined to do it. She said, file a motion, I'll consider it. It was never filed. And instead of raising the issue in the case, once it had been allowed and introduced into the case through a motion, Intrepid tried to dodge the need to file a motion in that case, to pursue appeals, and just said, there's a new judge on the bench, effectively at this point, Justice Branston retired, and they filed a new case to raise the issue, but it's the same issue that had already been made part of the 2013 case through the amendment was allowed. With that, I'll rest and await rebuttal. Thank you, Your Honors.
Thank you. Lundin PLLC, Neil O'Marahu of Lundin PLLC for White Oak, the senior creditor. So the issue presented on White Oak's appeal is, again, is the issue of whether payment in full has been adequately alleged in the amended complaint of Intrepid. And they only allege two facts. One is that the senior debt in January 2013 was $40 million, and that at some unspecified point, and we join with Selling Source in saying that these are transactions that happened while the first action was underway. But at some point, White Oak eventually got more than $100 million from Selling Source. Now, from that, Intrepid wants the court to infer that the senior debt has been paid in full.
As to White Oak, in our October 2018 decision, we said, thus the remedy standstill provision of ICA Section 5A bars this action unless White Oak is precluded from asserting it by having committed a material breach of the ICA. By the way, where does that phrase, committed a material breach of the ICA, come from?
It is the argument that they made in the 2013 action, Your Honor, is that it didn't matter that the debt had not been paid in full because White Oak had breached the ICA, which meant that they then could not rely on the protection of the remedies.
Is that something that we came up with?
No, this was it's a general theory of a prior material breach of contract, meaning that once we had materially breached the contract, allegedly, it's I think a
You
standard.
can't take the advantage, you can't take the advantage of the factors. So that's not actually in the agreement, it's just us recognizing that principle of law. So in this case, at page 34 and 35 of the record, there are all sorts of allegations against White Oak as having breached various provisions of the agreement, right?
No, the allegations on pages 33, these are allegations of,
For instance, paragraph 82, in April 2014, White Oak entered into an agreement with the grantors which required Selling Source to pay it $250,000 to satisfy the unsecured debt owed by Lone Star SPV1 LLC, Lone Star, an affiliate of Selling Source's controlling shareholder. And it then goes on and then goes on to something else about a $750,000 per quarter that you required Selling Source to pay, not as repayment of senior debt, and you thereby elevated. You familiar with those provisions of?
I certainly am, Your Honor.
Okay.
And so
Why doesn't that make it possible for the action to be, for Intrepid to go against White Oak?
because these transactions are all explicitly covered by the res judicata effect of the prior decision. This one thing at 82 concerns April 2014, 83 concerns April 2014, 84 concerns July 2014 to late 2017. All of this stuff was alleged. Lone Star was litigated in great detail in the prior action prior to and raised on summary judgment.
Are you telling me what's set forth in paragraph 82, 83, and it goes on for a couple of pages? Are you telling me that those allegations were in the prior action?
Yes, I am, Your Honor. That these are all within the time period of the prior action and are precluded.
I understand they're within the time period of the prior action, which ended after these years, but were these allegations made in the prior action?
I am absolutely certain that the allegations concerning Lone Star were made in the prior action. There were these repayments and transfers.
How about London Bay Capital?
Yes, that was certainly discussed. I don't recall as to the other ones, but as Your Honor can see, they were absolutely within the time period, and they could have been raised in opposition to summary judgment in the previous action, and they were not. Now, going back, unless the court may I briefly go back to the issue that we raised in our brief? Thank you.
30 seconds to do that.
They say that the debt was $40 million. We got over $100 million. But if you look at their paragraphs explaining why the court should infer from that the senior debt has been paid in full, they're all wrong, right? It doesn't address the interest. It doesn't address the fees. And it doesn't address the fact, as this court held, that White Oak and Selling Source have an ongoing right to increase the senior debt, right? We can lend them more money without violating the intercreditor agreement as long as the principal amount then outstanding, right, the current balance, the principal amount outstanding, doesn't exceed whatever the limit was in 2000 and, I wrote this down, in 2020, August 31st, 2020, an amount they never plead. So there are just too many unknowns here as to the additional amounts of money that White Oak is entitled to over and above the $40 million that they were owed at one point in 2013.
So when the plaintiff says that the most that could have been paid to White Oak as senior debt payments under the ICA was $46 million, where does that come from?
Well, they take the $40 million that was owed and they add another.
There's an additional $6 million provided for.
A $6 million that's provided for, that's described in paragraph 74 of the complaint. But both the idea that $40 million is the cap is incorrect because the senior debt could be increased by further amounts as this court held in the previous Intrepid decision. And also it doesn't account for interest, it doesn't account for fees, it doesn't account for anything like that. So this argument that $46 million is the upper limit is just absolutely wrong. And it's plainly contradicted not just by the ICA, but by this court's prior decision in what we call Intrepid 3, the most recent decision in Intrepid versus Selling Source that this court has reached, where you held exactly that interest was covered and that that the senior debt could be increased without violating the intercreditor agreement. If there are no more questions, thank you, Your Honor.
Your Honor, it's Jason Corral of Press Corral LLP. I'm here on behalf of the respondent, Intrepid. The note that's at issue in this case went in default in 2013. That's not disputed. The question was, could Intrepid sue on that? The case was brought in 2013, and that case alleged that because of the transactions that had occurred between Selling Source and White Oak, there had been a payoff of the senior debt. That case, we lost that case. And it went up, in fact, to this very court, and the court held that there had been no payment in full, and it ruled in 2018 that all claims and defenses in the 2013 case related to that payment in full were out of the case. But after the 2013 case was brought, there were, as is detailed in the complaint that we brought in 2019, there were approximately $100 million of additional payments that were made.
Were those raised in the first case?
They were not raised in the first
Because
case.
they occurred after 2013.
Because they, exactly, Your Honor. And because the issue in the 2013 case, there's a claim standstill. So we're not allowed to bring the case unless payment in full happened before we commenced the case. And defendants throughout the entirety of the case insisted and prevailed on the concept that we could not bring in evidence of payments after 2013 because that had nothing to do with whether the payment in full had occurred before we brought the case. So that case we brought the case as a second case. Now, the doctrine of res judicata is clear on this issue, that if there's facts that arise before you commence the first case, whether or not you allege them, it's res judicata. But if there are facts and events that arise after the commencement of the original case, and you can then bring a new action that's based on those claims. And the case of UBS Securities in 2011 versus Highland Capital, 86 AD 469, it's exactly on point. It's the same fact pattern. There was a case brought in.
We're going to talk about the amended answer, right? You haven't done that yet. So
sure, I'll be happy to address the amended answer.
Okay,
Absolutely.
So did that introduce into the lawsuit as transactions that occurred post 2013?
Correct. And at the time the amended answer was offered, the note of issue had already been, there was already been a note of issue. The case was kind of at its terminal point, and all of a sudden this answer comes up. Now, what happened is that this court's opinion in Intrepid 2 came after the IS court gave permission to amend, but before they actually filed the amended answer. Mm-hmm. So the IS court didn't know what this court was going to do, and when it found out, it said on the record, and this is on page 370 to 371, that the decision by the appellate division renders the entire issue of payment in full moot. So at the time the amended answer was filed to offer a defense about payment in full, that issue was already out of the case. And in fact, the very day that this court decided Intrepid 2, White Oak's counsel wrote the IS court and said that the payment in full issue is moved entirely from the case, and that it, quote, mooted the question of payment in full, making the demands for supplementary discovery relevant and necessary. Judge Cohen relied on all of this. At summary judgment, this issue came up again before Judge Cohen, and counsel for defendants represented that there was a hard cutoff in 2013, that the court could not consider any matters after 2013. Judge Cohen agreed with that, he accepted that, and he has stated multiple times on the record, both in the opinion that's on appeal now and in a prior hearing on this case, that he did not consider any facts after 2013 in the 2013 case. He did not consider any matters concerning payments, that it was simply never in the case. So this was a matter that was never litigated under the doctrine of res judicata. It's all matters that arose after the first case.
And what about section
Yes.
5A, which it talks about whether or not White Oak has committed any material breaches of the ICA?
Well, at this point in the 2019 case, it's really about whether there's been payment in full of the senior debt. There were a number of breach claims that were alleged in the 2013 action. Those were included in the 2019 complaint, but we agreed on oral argument that they would no longer be part of the case. And I think that's reflected in footnote 1 on JR 9 of that those allegations are no longer in the case. It's really about whether the payments are sufficient. And just very quickly, I know I'm red, but I haven't got a chance to address the White Oak argument. Very quickly, the White Oak motion is a motion based on documentary evidence that it is attempting to essentially say that it's impossible for payment in full to have occurred. And the problem is that there is no documentary evidence that was appended to that. There's no evidence about what the payments were. There's allegations about fees and amendments, but there's no documentary evidence about that at all. And in fact, White Oak admits in their reply brief that the documents they submitted do not utterly refute the claim, and of course, that's the standard. So with that, Your Honors, unless you have questions, I'll sit down.
Intrepid's argument ignores the reality that in long-lasting, complex litigations, the scope of the case and the temporal scope of the case can and often does change. You pointed out some of the allegations that appear in the complaint in the 2019 case, which were actually, they were also raised in the 2013 case, not through the original complaint, but through supplemental pleadings added later. And what happened in the 2019 case is Intrepid took the entirety of its 2013 complaint in the case that was then pending on a summary judgment motion, copied it, and added this one new allegation. Senior debt was paid off before 2019. That allegation, which was part of the amended answer, was made part of the case because Justice Branston granted the motion to amend. After this court's decision in the prior appeal, Intrepid again repeated its argument that it needed more discovery beyond just the documents showing the payment amounts to prove a breach, or sorry, not a breach, but payment in full had occurred. Orally asked for the amended answer to be stricken from the case, and Justice Branston's answer was, I don't have that motion before me. Bring that motion. Or pursue an appeal to the First Department if you think this issue's out of the case. Raise it with the First Department, seek clarification. Rather than follow up in the existing case, Intrepid filed a new lawsuit because they knew that would be their opportunity to restart the clock, reopen discovery all over again. That's not an option. When you have an existing case, issue gets introduced into it, you need to pursue your remedies in the existing case, not file a new lawsuit. Thank you.
Thank you both. Oh, I'm sorry.
1 minute, Judge. I disagree strongly that we admitted that our documentary evidence did not fully refute my colleague's position. What's really happened here is that they've alleged that because the senior debt is capped at a max of $46 million, payment in full must have happened. But our documentary evidence showed irrefutably that the $46 million number is just fantasy, that it is no basis in fact as a top ceiling for the senior debt. Their statement that that the senior debt could not have exceeded $46 million is just wrong. And so based on that, is it reasonable then to infer, despite the fact that their factual argument has collapsed, we would still infer that payment in full has happened, and I submit that it is not. In response, finally, to your honors question about paragraphs 82 and forward, I know Lone Star was at issue in the previous case as a breach of contract, and I believe 83, 84, 85, 86, et cetera, are simply instances of they're alleging that payment was received by White Oak. These are not allegations of breach per se. They're just listing the money that White Oak has received. This doesn't fall under the breach of contract category that was raised in the last action, but really hasn't been raised here. Thank you.
Now I'll say thank you. Thank you all. People versus Carlos Santana.
Good afternoon. Mary Catherine Smith on behalf of Carlos Santana. Mr. Santana sold less than a half gram of cocaine to an undercover police officer at a party after that officer approached him, and he received the maximum probationary term of 5 years. In January, he will have been under supervision for 4 years. This court should reduce his term of probation to 3 or 4 years because Mr. Santana's crime was relatively minor, it was nonviolent, and he has strong support from his family and potential to be a productive citizen.
Where does Mr. Santana live?
Currently, I'm not in contact with Mr. Santana, but he is under probation in Maryland, as far as I know.
In Maryland.
Yes. And his
Not Pennsylvania.
Sorry, what
Not
about?
Pennsylvania in Maryland?
Not in Pennsylvania, as far as I know.
Didn't he go to New Jersey and then Maryland?
That is to the best of my knowledge.
First probation
it
was transferred to New Jersey and then to Maryland.
Yes, Your Honor. Mr. Santana's crime was relatively minor as far as low-level sales of drugs go. This is less than half a gram of cocaine. Even when you add in the amount of cocaine that Mr. Santana had on his person, it's still less than a gram, less than a teaspoon. And while drug crimes are relatively serious, this court has reduced sentences in other cases where there are controlled sales in the 3rd degree. In Rodriguez, this court reduced a probationary sentence from 5 years to 3 years. In Burgess, this court reduced a probationary sentence from 5 years to 4 years. We'd also like to point to Mr. Santana's family connections. I realize that, to the best of our knowledge, he does not live in Pennsylvania, where his 3 children reside, but he does have 3 children, and that is strong motivation for someone to be a productive citizen. He also has an employment history. He was employed at the time of sentencing. If I may just turn to the purported appeal waiver, we would argue that the oral colloquy here was not thorough enough.
Why not?
Yes, Your Honor. This was a relatively brief appeal waiver colloquy. The court explains to Mr. Santana that the right is separate and distinct from his trial rights. It then says that a higher court will not review what happens in this court, and then says that the only claim that would survive would be an illegal sentence. But then in the next sentence, the court says that other claims are in the written appeal waiver. This is problematic because it's a bit confusing. Does he have a right to challenge his illegal sentence only? Does he have a right to challenge a right to challenge that survives the waiver? Other claims, and it's also not clear on the record that the court created that Mr. Santana actually read the appeal waiver. The court does ask Mr. Santana if counsel explained every part of the appeal waiver to him, but Mr. Santana was appearing virtually. He did not actually sign the waiver. It was signed on his behalf by his counsel.
And the people objected to that, correct?
Yes, Your Honor. The people did object to his to that surrogate signature. And I think in combination with the muddled nature, the very brief explanation of the waiver of appeal, with the fact that the record isn't clear that he had that waiver in front of him, and he definitely was not the person who signed it, I think that this court can find that that waiver of appeal was not knowingly, voluntarily, or intelligently.
When was he released from incarceration on his May 11, 2017 attempted assault in the 2nd-degree conviction, on which he was sentenced to 1.5 to 3 years?
I apologize, Your Honor. I do not know exactly when. Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court. Hunter Barron for the people. Just to start at the top.
Counsel, do you know the answer to Justice Friedman's last question?
No, I don't actually. I was just checking our brief to see if it says, and I don't believe it does. So apologies for that. It should be indicated in the PSR, but apology if it's not. But
so he has been on. He was given 5 years probation?
Yes.
And it's been 4 years so far?
Yes.
And he's in another state?
I believe so, to the best of our knowledge.
Presumably under supervision in the other state?
I will say, Your Honor, that I recently ran his NYC sheet yesterday, and there was an indication that there was a notation that said probation absconder, but we haven't been able to corroborate that notation in any way. As far as we know, when we reached out to probation in June, he was compliant as far as.
And no arrests, obviously. Compliant means no arrests.
Not that I'm aware of, Your Honor. But there was a valid waiver of appeal signed in this case that forecloses his current
This conviction is from January 26, 2021, right?
Yes, I believe so.
So how has he served 4 years of probation? I mean, that would take you into 2025.
2021. I'm sorry, Your Honor, I believe. So I think it's been over 3 years at this point. January 26, 2021. So it's over 3 years, if I'm getting my date right. So about 3.5.
January, you said?
January 2021 is when the judgment was. So 5 years it would be, yes.
That's
And I believe the maximum
almost 4
expiration
years. It'll be
is.
4 years and 3 months.
I'm sorry, Your Honor?
It'll be 4 years and 3 months.
I think it's 3 years and 3 months.
3
Or
years.
3 years and, I'm sorry, I'm not very good at math. 3 years and 9 months, I believe. If it's January 2021, it's September, so 8 months. Yeah.
Okay.
But anyway, Your Honor, there was a valid waiver of appeal signed in this case that forecloses his current claim.
His lawyer signed it.
His lawyer signed it on his behalf.
Defendant wasn't there, correct?
Well, it was a virtual appearance, and the judge asked him, have you gone over every part of this waiver with your attorney? And the defendant said yes.
Did the judge ask him, did you read this waiver?
And he did not ask him that.
And I
But
want to just follow up with this. The judge says this, in addition to that, as a separate and distinct part of your plea agreement, you are giving up your right to appeal. That means you will not be able to ask a higher court to review what happened in this court and will only be able to challenge your sentence on the ground that it is illegal. You will retain the right to appeal on some other legal issues, and those are set out in your written waiver of right to appeal that your lawyer has. You think that's a good waiver?
I would, Your Honor. I mean, I think could the judge have explained what those other legal issues were? Of course. It would have been above and beyond, though, what the requirements of the Court of Appeals and this court have set out for these kinds of waivers. Really, the important thing is that the judge made clear that this was a separate and distinct part of his plea agreement, separate from the other rights that are forfeited by pleading guilty.
And the prosecutor objected twice to this occurring, correct?
Well, Your Honor, yes, they objected to that. Well, I'm not sure about twice.
Well, let me read it for you, Mr. Broski. Judge, just for the record, I just want to renew the objection I have previously made via email to the court about having defense counsel sign the paperwork on defendant's behalf. The court, you have made your record.
Yes, Your Honor. My interpretation of that objection is not that this wasn't a valid waiver because of this signature issue. Really, it was just trying to perhaps go above and beyond what this court requires and what the Court of Appeals requires.
This plea was taken during COVID, of course.
Yes, during COVID. That's what the virtual appearance.
Did you know, did probation recommend a sentence of incarceration on this crime?
I'm not sure, Your Honor, about that off the top of my head. It should be indicated in the PSR.
It was a small amount of drugs, am I right? That amount is.
I think it was about 0.3 grams of cocaine during the sale and then 0.6 afterward. But, Your Honors, this particular defendant had a number of prior convictions, an attempted assault in New York, a robbery in New Jersey.
That was some years before this. He had already been off of probation. He wasn't on any sort of supervision at the time this happened. So
some years before, Your Honor, but I think it's a strong justification that this is an above minimum probationary sentence, given this long record and the
right,
fact
but
that he
given
was
that,
a predicate
my question
offender.
was, it is a small amount of drugs.
I'm sorry, Your Honor. Could you repeat that?
It is. My question was, that amount is a small amount of drugs, right?
Yeah. I guess I'm not qualified to say what's small and what's not small, but
You
0.3.
prosecute these things. You know how much, you have to determine that to determine which charge it is.
Well, I suppose, Your Honor, it was enough drugs that that incurred
So
these
a
felony
teaspoon,
charges.
the entire amount.
The
would be
entire
fair.
amount?
It would be fair to say the entire amount was about a teaspoon, consistent with what counsel said. That still can.
I guess I'm not familiar with
Thank you.
the exact volume. I'm sorry, Your Honor.
Also, how do you respond to your friends citing People v. Burgess, where we did reduce in 2022, and People v. Rodriguez, which we reduced in 2018 with similar background? Do you want to respond to that? You don't have to if you don't want to.
Yes, Your Honor. I would just point out that this defendant does have several prior convictions, several in Pennsylvania, an attempted assault in New York, and a robbery in New Jersey. The amount of years that it goes back is less significant than the fact that those convictions are there and that they justified this above minimum sentence, deserving of more supervision.
This is at least his fourth conviction.
At least. I'm actually not off the top of my head remembering how many convictions were in Pennsylvania.
And I'm counting, I don't know, it sounded, from your brief, it sounded like there was more than one, but I'm taking the lowest possible number. One in Pennsylvania, one in New Jersey, the assault, and then this conviction.
Yes, that sounds about right. Although, again, I can't confirm how
2007,
many.
2017, and now this one.
Okay.
Thank you.
Thank you, Your Honor.
Contrary to respondents' contention that the trial court went above and beyond the requirement for appeal waivers, in Oquendo, this court noted that the best practice is to secure a written waiver in combination with a thorough oral colloquy. This oral colloquy was not thorough, and the written waiver was secured in a way about which one could question whether or not the defendant actually had that paper in front of him and whether or not he read it, because the record was not created.
Is it common in your experience for the prosecutor to object to the manner in which a plea is taken?
No, Your Honor, I have not seen that in a transcript before this case. If this court has no further questions, we'll rely on our brief. Thank you.
Thank you. Thank you both. Coyle versus Dos Santos.
Good afternoon, Your Honors, and may it please the court. Ross Frisha for plaintiff appellant in this matter. The motion court erred in granting summary judgment to defendant owner here on the ground that co-defendant Dos Santos was the sole proximate cause of plaintiff's injuries, when in fact it was the hazardously slippery stairs that were also a proximate cause of his
Counsel,
injuries.
this was a police officer who testified in the grand jury in addition to his testimony here.
Yes, Your Honor.
And he testified to a violent account where this person was enraged and grabbed both he and the other officer, violently pulled them in before propelling off of the wall to push him down the stairs. Isn't that a superseding event to the slippery fall, to this, even if they were slippery stairs? And haven't we already said that slippery marble is not an actionable claim?
Right, so to address the first point, the pushing off of the wall, if you look at Officer Coyle's testimony at page 153.
You're looking at the grand jury testimony, which is a part of the record?
I'm sorry?
Are you looking at the grand jury testimony, which is a part of the record? Is that what you're reading from?
In this case, I'm looking to the testimony for this case, which is
The grand jury testimony is part of this record, right?
Yes. Yes,
and
it is, Your Honor.
it's accepted as true.
Yes.
Correct? It was under oath.
Yes, and I think that the testimony that I'm going to point to now at page 153, it further elucidates what happened. So it's nothing contrary to what you just said. It's that the co-defendant, Dos Santos, pushed off the wall while they were engaged in a struggle, and Officer Coyle saw him put his foot against the wall to try to push off, and at that point, Officer Coyle placed his feet in a quote-unquote combat stance to, quote again, try to actually avoid being pushed. But he testified due to the marble, he wasn't able to gain any traction to actually hold his footing. And then he was forced backward down the stairs where he tried to gain his footing on multiple steps as he descended down the stairs. And that second part of what I just said is on the record at page 148. So
I don't think it matters, but I believe in the grand jury, he said that he took that stance after this person ripped the badge off of his fellow officer. That's when he took the stance, which was before he was grabbed and pulled in and then thrown down the stairs.
Right. The way that I see it here is that you're right in that the co-defendant hadn't assaulted the officer from Maine, his partner.
In other words, it didn't matter that he had this stance, because even with his stance, the violent nature of this individual propelled him down the stairs.
Yes, but if you look to the record at page 153, again, it was after he noticed that Dos Santos put his foot up against the wall to push that he took the stance, and then he slipped.
That's not what I read in the grand jury testimony, but I don't think it matters. Either way, he was pushed violently down the stairs.
Okay. But after he was pushed, you also have the testimony that he tried to gain his footing on the steps as he descended. So he couldn't gain his footing or gain purchase on the slippery steps as he went down the stairs. And just to address your second point as to the applicability of the codes, while the case law does say that smoothness in and of itself on a marble step is not actionable, we have here statutory provisions that were violated, and namely New York City Administrative Code Section 27-375, the Building Code, New York City Building Code Section 1003.4, and also...
I think the year of this building didn't require it to adopt that, that code that you're referring to, which I think has to do with the treads.
Yes, Your Honor. So the building was...
it wasn't required.
Well,
so it wasn't out of code.
So the sticking point here is that if there was a renovation or replacement, then the newer code, whenever that replacement happened, could have applied. And that's detailed in the case Sarmiento v. C&E Associates, 40 AD.
But you yourself are saying that the stairs were worn because they weren't, there wasn't any repair to those steps. I don't think that's what you're saying.
Well, it's not that they were worn, it's that they were slippery marble steps. I'm not sure if there was an allegation of them being worn, but we have defendant owner's own witness when asked if the steps were replaced or repaired during the time he worked at the building, where he said, yes, of course. That's on the record at page 273. When they asked who performed the replacement, when the attorney asked who performed those replacements, he responded, they sent a company to change them, to replace them, referring to the steps. So in that case, there would be a tribal issue of fact as to whether the steps were replaced or repaired, the nature and extent of the repairs, and then the applicability of the statutory violations.
Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. Monica Romero for Decatur. There are 6 points that I would like to make briefly. The first is this injury falls squarely within the firefighter's rule. This is an injury that happened within the line of duty, and
This is not, I don't know that the firefighter's rule is applicable to a private residence.
It's applicable if the petitioner is a public police officer or firefighter. And in this case, this injury happened because he was in the line of duty, and he admits that it happened, that it meets the definition of a line of duty injury during his deposition testimony 163 to 164. It qualified within the police department's definition. For that reason alone, the claim shouldn't matter. But regardless, and that leads me to the rest of my points, any claim under general municipal law would fail. First and foremost, as you noted, Your Honor, marble steps without more are not actionable. And that is the only defect that they allege on the record. That's it. My third point, none of the codes cited by plaintiff matter, because the applicable code is the 1901 tenement house law, because Decatur was built in 1926. Now, their expert says that because the incident happened on the 2016, that a newer code applies. That is not true, and it does not matter. We have cited in our brief case law by the Court of Appeals in the Appellate Division that states that no, what matters is the date of a building being built. However, on reply, they tried to get around that rule by raising several first arguments for the first time on reply on appeal. The first argument that they make on appeal, and it's inappropriate because it was just raised on reply, is that a substantial renovation happened, and therefore that means that they should comply with a newer code. First of all, it's inappropriate. There's no factual basis on the record for this court to conclude that a substantial renovation happened. Neither them nor we investigated that claim because they did not raise it. So it would be inappropriate for the court to rule on that issue. But even if it were properly before the court, it was not a substantial renovation. Under Hyman v. Queens County Bank Corp., for a substantial renovation in a building to be considered to be falling under that category, the renovation itself needs to exceed 30% of the value of the building. Whether the stairs were repaired or replaced, we don't know because they didn't investigate that claim, nor did we. Now, they cite codes that are non-specific under this court's precedent. And then for the first time on reply on appeal, they cite the codes 27375 and 1003.4. They did not raise those codes on any of the briefs in the lower court or on this court until reply. Regardless, their expert does not allege a violation of those codes. Finally, Your Honor, they on appeal argue that Anderson v. Creston Associates stands for the proposition that 272005 is a specific code. That's a blatant mischaracterization of that case. That case states the court was saying that alterations to the building made it unclear whether the 1968 building code and 1929 multiple dwelling law applied or the New York City administrative code. That's what that case stands for. But those arguments were inappropriately raised on appeal. They are not properly before this court, and there's no factual basis for them to now rely or think that the court can search into the record and find any support for that.
Thank you.
Thank you, Your Honors. Just to address some of the points of counsel, in the case Anderson v. Creston Associates, that was a case where presiding Justice Renwick sat. At the very end of the decision, it says, furthermore, on this record, a factual dispute exists as to the applicability of the Housing Maintenance Code, New York City Administrative Code 27-2005. And that was something that was raised in the proposed amended bill of particulars to be adjudicated with the GME 205E claim. So the fact that that there was a factual dispute as to the applicability of that code, that shows that it could be used to support that
This is a
cause of
different
action.
case. Anyway, your next point.
I'm sorry?
I said this is a different case, different facts here. Your next point is?
Yes, so my next point is that the other two codes were in his, in plaintiff's bill of particulars in the record at page 91, specifically 27-375 and New York City Building Code 1003.4, and the case Sarmiento v. C&E Associates clearly states, and that was a case where a plaintiff was injured by falling down slippery marble stairs, and the defendant failed to meet its prima facie burden in showing the inapplicability of 27-3.75, that provision could be used to support a statutory violation and thus a claim under GML 205-E. And if there's any other questions, I will rely on my brief.
Thank you.
Thank you, Your Honor.
U.S. Bank Trust versus Stewart.
Good afternoon, Your Honors. My name is David Bythewood. I'm here for the appellant, Doris Stewart. May I proceed?
Yes.
This is a foreclosure matter, and the birth of the foreclosure to acquire the home of Doris Stewart was in the matter of J.P. Morgan Chase Bank versus Doris Stewart. In that particular case, J.P. Morgan Chase was challenged by the motion of Doris Stewart saying that it did not have standing to sue. And the basis for it not having standing to sue was that
Counsel, just interrupted. Did you make the standing argument below?
I beg your pardon?
Did you make the standing argument below?
I did not make any argument below. I wasn't the attorney below, but it
Was it made below, counsel? You know why I'm asking this
I beg your pardon?
Was it made below by anyone?
No, it was not made below.
That's the question. So can we consider it?
Why should it be considered?
Yeah.
The reason it should be considered is based upon res judicata and based upon the fact that Justice Kahn referred to and relied on the decision of Joan Kenney that dealt with the standing issue in his decision to deny the motion of Doris Stewart. That is on page 5 of the record. That's the decision and order appeal from. When he looked at that and he made the determination that because relying on Justice Kenney's decision, which stated that that the plaintiff failed to present any evidentiary proof as to the original loan and the assertion that its predecessor in interest, Washington Mutual Bank, sold and assigned the pertinent mortgage. So we're talking about an impossibility there, and because he used it in his decision to deny the motion of Doris Stewart, then it becomes fair game to go after.
I mean, at this point, there's been a lot of, more than one summary judgment motion filed below, right?
That is correct.
A lot of dispositive motions, and she didn't say anything about standing in any of those dispositive motions, correct?
I'd say that those attorneys were not really up to par with regard to the case. Of course, we could say, yes, maybe we should wait longer and do a 50-15A3 motion and go after this U.S. bank based upon fraud, misrepresentation, and misconduct because it's saying that it has a mortgage that it doesn't have, because J.P. Morgan Chase never proved that it had any right to the mortgage. It never proved any assignment, and there's nothing in the record whatsoever in this case that shows any assignment to J.P. Morgan or any ownership by J.C. Morgan of that mortgage, and because they don't own it.
But U.S. Trust has a copy of the note, right? And they U.S. Trust, the plaintiff in this case, has a copy of the note, and they attach it to their complaint. Isn't that sufficient?
No, it's not sufficient. I mean, you're thinking of Aurora, and let me speak on Aurora, if I may. First of all, I'm going to point to the Supremacy Clause of the United States Constitution that says no state shall make any law that does not abide by federal law. And then I take you to 42 U.S.C. 1981, which is a civil rights statute.
Counsel, this is a heavy lift because we've been following Aurora quite a lot around here. I don't know. You're trying to say we shouldn't follow Aurora?
That's correct.
Okay, I don't know.
May I finish?
Well, the light's on. You got a few minutes to say whatever you want.
42 U.S.C. 1981 is a two-pronged civil rights statute. And one prong of that civil rights statute says that a person, it is a civil right to be able to enforce your contract the way it is written. There has never been a mortgage that has said that the mortgage follows the note. This is a fiction that was created by the Court of Appeals, and I think that what happened there was that 42 USA was not before them. I would say to you that when you look at Aurora, you have to look at it in light of 42 U.S.C. 1981, which says that it is a civil right of the citizens of the United States, each and every one, to be able to enforce their contract as written. And when you go to the United States Supreme Court with regard to it, because there are too often times when people do not understand that that 42 U.S.C. 1981 is a two-pronged statute. The prong of the statute that applies to the enforcement of a contract, the United States Supreme Court says in Patterson versus McLean Credit Union, which is in my reply brief, they say very carefully, clearly, that race does not apply. So it applies to everyone. It is a civil right that applies to you no matter what your race is, and that's by the United States Supreme Court. And because of that, and because of the supremacy clause, if you say that you have to follow Aurora, notwithstanding 42 U.S.C. 1981, then you're saying that the supremacy clause of the United States Supreme Court is ineffective.
Thank you, counsel.
Good afternoon, Your Honors. Harry Tawari with the law firm of Locke Lord on behalf of the respondent, U.S. Bank Trust. Your Honors, I think our respondent's brief still addresses all of the arguments that my colleague just made. So unless Your Honors have any questions, I will rest on my brief.
Thank you.
Thank you.
Nothing further? Okay, thank you both. Have a good evening.